the LCAs, the I-129s, the 797s, how they came up with the regular rate, the prevailing wage, how they came up with the actual wage, what they paid the workers. All that is open access for the public, especially for us when we go do an investigation. And they have to maintain the documents as required. And they have to cooperate in an investigation, which means they have to have all that available and have to be willing to give it to us immediately, or upon request, obviously. And then provisions H and I, which are some of the minor, more clerical things. But at the end of the day, what is most important for you is this. We want to look at what should you get paid, and that's in 62G, which addresses the prevailing wage. That's the other fact sheet that's really important for you guys. And I think we have it here. Okay, that's right here. So we want to, it explains the prevailing wage, it explains the actual wage, and the required wage. So the prevailing wage is what is going to be, they have to do some research. They need to find out what is it that they're paying at this location for this job. And USUS has a go to our website. You go online, you put computer analyst in Michigan, and I have 3 years of experience, and it says it's $25, or $50, let's say 50. And then you have to then look at what your actual wage is. Okay, so the employer has to do a little bit of research and see, okay, I am paying my computer analyst $35, no, $65, right? And so he has to compare the two and then decide that it has to be a higher wage. The rate that he's going to be paying the H-1B worker has to be higher than the prevailing wage and the actual wage. So they come up with a number, and then it gets approved through you guys. ETA, I'm sorry, I'm pointing. We don't get involved in that, other than what gets approved on the LCA is what we then enforce. So you want to make sure you get a copy, that is a requirement, that if you come in under an H-1B visa, you get a copy of the LCA. So you want to make sure that all the rates are correct, because if there is a problem, Wage and Hour is only going to be able to enforce the 35 or the 65 or whatever it is that's at the rate that's in the form. Okay? Now, the fact sheet 62H, which is further down, talks about what H-2 workers cannot be asked to pay. And so, bottom line, there are certain things that you can't pay. Okay, so you can't pay for the penalty for finishing employment early. You can't have to pay for the 500 statutory 500 fraud protection fee imposed by USIS. You can't be asked to pay for any attorney's fees, filing fees for the LCA, filing H-1B visa fees, any tools and equipment, and any travel expenses for business. You are allowed, what they can do is pay for taxes, union dues, insurance, and voluntary deductions for benefits. I have done numerous investigations, and I did a huge H-1B case a couple years ago where the employer had like 200 H-1B workers, 200 workers, 187 of them were H-1B workers, and he did not have proper LCAs. All of them were located here in Florida. And they were, the address was always in Florida, but they worked in Michigan, they worked in Detroit, they worked in Denver, they worked everywhere. Of course, the LCA is going to have the lower rate. When you're working in New York, it's a higher rate. In addition to that, the employer was paying a lower rate that was on the actual LCA, which is already lower than it should be, and then paid a per diem rate. Which the Department of Labor's position is that if it's a per diem rate and it's not taxed, you don't get credit for it. So you need to make sure that the employer understands that you can't be asking for other money on the side. The Department of Labor will not accept it. We had it went into litigation, we settled, and it was 57 employees do $160,000. So it does happen. I've also had cases where it's simple mistakes, where the contract has ended and the employee was still abroad, came back, and was benched without knowing, because again, it's a third. Many of these employers will bring in 200 workers and place them all over, and they don't know where you're at. They don't know if you're waiting for work. And under H-1B, you can't be benched. If the work is there, or if you're available for work, you have to be paid. So the gentleman was due a month or so while he was waiting for work, and then he got another H-1B employer to sponsor him. So you have different scenarios in the H program, but I think knowledge is key. If you know what the employer's responsibilities are, then you kind of know what your benefits are, or what it is that is required. Bottom line is you're coming here to work, you're coming here to get paid, and you want to make sure that and you're sometimes very vulnerable because they're holding your visa, and you want to make sure that you know your rights. You need to be paid the LCA rate. You need to get a copy of the LCA. You cannot be benched. You can't, if you're available for work, you have to be paid. And you can't be asked to pay for fees that are obviously requirements of the employer. So that is basically, for me, the bottom line for you guys. But I do have a few more sites. I have the www.dol.gov. That's our website. Now, the H-1B visa, since you guys are students, the 20 CFR 655-700 is the section in the regulation that talks about H-1B. So if you want to educate yourself on the actual regulation or the actual law, that's a good place to go. And then you're going to be looking at the different forms. The LCA ETA 9035, which is the attestations and promises by the employer of what they're going to be paying you. And then, I know ETA is going to be talking about this, at the I-129, which is employee specific with your qualifications, and the I-797, which is notice of action. And that's the eligibility date to work and the employer's wage obligations to date. So you get the I-797, and you should be working within 60 days of that time frame. So I don't know if you have any questions. I know I'm going through it very quickly.
Yes, before we open up to questions, if you want to ask you more things in the window shot. You guys understand, everything that she explained? Yeah. Yes or no?
Yes.
More. Yes. Okay.
Yes, speak up.
Great, yeah, good. And you have to pay attention to the LCA. What she is showing you, and what she was telling you is, your employer can't cut the deal between him and you.
Right.
That's not what. The deal is between him and the Department of Labor. He can't tell you, I'm going to pay $85 and say, I'm not in a project, I'm not going to pay. It's not going to work. Because the LCA was submitted to Department of Labor, and he promised that he's going to hire you and pay you this much, and he got to pay. He can't come and tell you, I won't pay you. Second, if you're working in a consulting firm, or you're not from an IBM or Accenture, but a lot of consulting firms, individual consulting firms, you have to understand your employer can't tell you, oh, you're not making money for me. I need money for my H-1B filing that I filed for you. And that's what she was telling you. I need my attorney fees. I paid $3,000. I need that money. He can't ask anything, those money from you.
And I think, to me, and you're here to work, and they're asking for you guys to come in and help them work. So they're required to pay for your fees. That is a cost of business for them, and they have to pay you the required wage. Now, if you have a problem, you need to call the Department of Labor. We have a W-4 that we fill out. It's a complaint form, and then we would interview, and we would talk about the specifics of your issue, and we would obviously want to look at your LCA and all your different forms, and then it gets sent to the regional office, and they decide if it's a credible source or an agreed party that would be filing, and then it would be set up for an investigation.
And you guys also have to understand, when you go to the QAL, they're not going to throw you under the bus. They're not going to tell your employer, you file the case. No. They will look at all the employees. When you file a case, they are investigating the firm, just not your case. So the employer will not know, okay, you file the case on me, I'm going to fire you. No, that's not going to happen. And also, as she was talking about different states, what she's saying is, okay, you find an employer, the minimum wage, this changes from state to state. if an employer saying, you know, I have.
City to city,
City, yeah,
right?
I didn't know that, yeah.
It's different.
So he's hiring you in one state or in a city, and you're moving on to a different city, which is far more expensive, then you want to make sure that you have a copy of the LCA and you're getting paid the rate in that particular city or state. See, this is all, that's your money. So now that you have an idea, you can ask questions.
Yes, sir.
Yeah, you did mention that there'd be some issues with regard to our terms of employment, which we have to talk about specifically with the Department of Labour. Would that include any occupational injuries or injuries sustained on the job while working?
Well, you know, that would be more of an issue, OSHA issue. We don't deal with any of the injuries on, you know, if you get hurt. We're looking at the work, at the contract. Anything like that would be dealt more either with an OSHA, because if there was an issue with how you got hurt, I believe workman's comp, I say, would still apply to you through that venue. But the Department of Labor is really looking at your wages and what you're doing and where you're working. That's what we're looking at when we're looking at an H-1B. And then obviously we want to look and see is the employer, when we're doing a full investigation, are they properly disclosing all their information? I'm sorry, are they properly making sure that they don't displace a worker? Are they advertising the job? And those are other requirements that the employer has, maybe not pertaining to you, but that we would be looking at.
So the one I mentioned is more of a personal issue which has to be dealt with the employer and maybe an insurance agency.
Most likely, yes. Not something that we would deal with.
Okay.
So, does anybody else have a question, sir? No? Wyatt? Anybody want to come in on an H-1B visa? Yeah? Yeah?
And also, you know, one more thing that I need to mention is you can have a copy of the LCA.
They're required to
But
get it.
if your employer says he can't give you a copy of the LCA, you can't say that. And once you graduate and move from F1 to H-1B, which is, remember, it's a valid temporary non-immigrant visa. So he needs to give you a receipt number. Nobody can hold or put a leash on you and say, you know, I can't give you a receipt number. No, he needs to give you a receipt number. He needs to give USCIS, when they will talk about it. He needs to give you immigration documents, and these are your documents.
Okay. Like I said, that website is really good. Since we only have one person that's kind of actively looking into it, you certainly have our contact information. You can get my contact information. If you have any problems, you can call me, and we could take your information and address it. Because we are here to help. We want to make sure that you are not wronged, and that the employer doesn't wrong his local workers as well.
And you can come back to us anytime. You know, that's the whole point of this. Even if it's not, they're talking today and we're gone. Graduate and go. You know, you can always send me an email. My card is here. Or else you can contact one of them, and you know, we'll be glad to help.
Okay. Thank you very much for your time.
He's got a presentation, I'm not sure if it's gonna connect, but if not, you've got backup, just in case.
So a lot of brochures here and, you know, cards.
And we'll get the stuff, sorry, afterwards, sorry. Yeah, I know, I feel the same way. Break a nail here.